I think. Yep, it's working. Great. So we can go ahead and get started. We can start by introducing ourselves, Maggie and I. My name is Bradley Showman. I'm the pro bono coordinator and staff attorney here at Legal Services Vermont. And I've been here for a couple of years working on the clinics here, and looking forward to having all you folks here. And for folks who just popped in, we are recording the session. You should have that notification up top. Feel free to turn your camera off or leave it on. For the most part, we'll be recording the actual PowerPoint when we get to it. And Maggie, if you'd like to introduce yourself.
Thanks. Hi, everyone. My name is Maggie Fry. I'm the managing attorney at Legal Services Vermont, where I've been an attorney for the last 12 years and done several things there. But right now, my practice is primarily eviction defense. Thanks.
All right. So I'm going to go ahead and share my screen. And you folks should see the PowerPoint and only the PowerPoint. Maggie, is that right?
It looks right. Yep.
All right. And again, I'll do occasional reminders, but just for folks who come in, we are recording this presentation. Feel free to keep your cameras off while we're doing that. And slideshow. All right, I'm going to go ahead and start the slideshow. Okay, so Maggie and I will go ahead and we'll go over this presentation. We'll email you folks the slides after the presentation is over. But for now, we'll just go over everything here. So our rent escrow clinics, they operate in 4 counties: Addison, Chittenden, Rutland, and Washington counties. The clinics allow attorneys to provide same-day legal counsel and representation for defendants in eviction cases at the rent escrow hearing by a limited appearance. We do this to help kind of even the playing field a little bit between attorneys, between landlords who are often represented by attorneys and tenants who are often not represented by attorneys. And the opportunities to volunteer, again, are in our 4 counties. Rutland and Addison are mainly in person. However, Rutland's recently went to a hybrid model. Chittenden is also a hybrid model now, and Washington is our only county that is solely on WebEx. So what is rent escrow? Rent escrow is any eviction proceeding, so not just for non-payment of rent, but any eviction proceeding where the tenant owes rent and is behind on rent. Landlords can seek a motion to pay rent to the court. So again, the underlying eviction could be for any reason. And landlords, the reason that landlords might do this is to kind of mitigate their damages while a eviction is pending. They don't get this as a matter of course, as we'll talk about a little bit later in the presentation. The tenants actually have to owe rent and be behind on the rent in order for the landlord to actually obtain a rent escrow order. And the cost of having a rent escrow order is potentially significant, because if a tenant misses a payment, they can be evicted by a writ of possession for failing to miss that payment even before a merits hearing. So they could potentially have defenses and things of the sort that they would like to raise. However, if they're unable to pay the rent while the eviction is pending, they can actually lose possession prior to being able to raise those defenses at a merits hearing. So rent escrow is a critical time to help tenants preserve their housing. So up until about next week, Vermont's Emergency Rental Assistance Program has given tenants a lot of leeway in order to stay in their housing and avoid the eviction process entirely. Currently, no new applications are being accepted unless tenants are in an eviction proceeding. And after November 30th, no new applications will be accepted at all. The rental assistance can help pay the opposing party's attorney's fees and court costs. And it was a powerful tool for rent escrow. And we'll discuss VRAP throughout the presentation. But again, for the most part, the program is ending at the end of this month. It will continue on in a very limited basis after December 1st. But again, no new applications will be accepted. No new rented to court payments will be made through VRAP. And for individuals who are on reach up, they might have a little bit more leeway as well. We'll talk about that throughout the presentation. But for the most part, after November 30th, VRAP as we know it is not going to be as useful of a tool as it has been for folks who've been working with us for the last couple of years. So we did this presentation in, I believe, August 2021. And so our clinic started back at that time after the eviction moratorium during the COVID pandemic expired. And VRAP helped a ton of tenants stay in their housing and avoid eviction entirely. What we did notice, and some of our colleagues went through each eviction case filed to kind of come up with this research. But as tenants have been able to pay rent, we saw landlords increase the amount of no-cause evictions from 20% of all evictions to about 50% of all evictions. So even though tenants had the ability to pay rents and cure any arrears and things of that sort, even get the landlord's attorney's fees and things of that paid, if they did find themselves in the eviction process, a lot of the times that didn't cure their housing because the landlords wanted to evict them anyway, and Vermont law does allow them to do that. As I said, new concerns moving forward. The VRAP funds are running out soon. No new applications after the 30th. And even as of now, a lot of households are out of their 18 months of VRAP assistance. And those increase of no-cause evictions, even if you do have the money to stay, still will result in the loss of your housing if the landlord proceeded with the no-cause eviction termination correctly, which we will talk about. There's some housing statistics about why this kind of work is important. So you'll notice that homelessness surged during the pandemic. And these are, I can't remember the name of the state agency. I should have it in the notes here, but the notes are not visible to me. But this is from our homelessness census. So homelessness in Vermont actually more than doubled during the pandemic. And that's with a good amount of rental assistance keeping folks housed. So you went from just over 1,000 to 2,500, 2,700 people experiencing homelessness. Rents have increased quite a bit. So Vermonters must earn $23.68 to an hour full-time to afford a 2-bedroom apartment, according to VHFA. And you'll see that a lot of our clients on the low-income side of things, some of our lowest income clients might be on SSI, which is a form of Social Security. Social Security, when I call it Social Security, but it's a form of benefit administered by the Social Security Administration for folks who are very disabled with limited work history. The SSI benefit for individuals is $893, and for couples is $1,360. So the poor in Vermont have limited ability to pay for housing. As rents increased and things of that sort, it's tough. And the vacancy rate for homes is about 1%, whereas statistics say a healthy rental market usually has a 4 to 5% vacancy rate. So it's important when individuals have housing is that they keep it. And that's part of what the Rent Escrow Clinic does. We'll talk about things like if housing is unsustainable for that person. I'll talk about things like negotiating a soft landing so that they can move on with limited damages to themselves and things of that sort. But for the most part, we will focus on ways to help keep people housed in order to reduce the resulting amount of homelessness in the state. And with that, I'll hand this over to Maggie.
Sorry, I muted myself. Thank you. Do you mind going to the next slide? So I'll talk a little bit about what happens when you volunteer at the rent escrow clinics. We have both in-person and WebEx options. I did hear that I think Washington is going to move to a hybrid model probably sometime next year, but I think we're waiting to see what happens with that court. So if you are going to be volunteering with us and it's in person, we suggest just checking the masking policy before you come. You can ask the court directly. You can also check with us. But things are kind of in flux with that. And I think, it depends on the courthouse. It depends on the judge's preferences. It's good to just kind of know ahead of time. Show up about 15 minutes before the first case is docketed. That's usually, the majority of our clinics are in the morning, so 8:30 or 9. Addison County is on Thursday afternoons, so they started around 1, but that can vary. So you'll find us at the courthouse. We're usually hanging out in some of the meeting rooms that are around the courtroom or sort of scattered about. And you're welcome to just check in with us and get started. Before each clinic day, we prepare a physical paper file for each defendant. And so that paper file consists of all of the paperwork that we have. So, things for us to do an intake and follow up with that person later. Just some other paperwork such as limited appearance forms, the notice of appearance for the client, and of course their court file. We have access to those in the public portal, and we usually print a court file so you have easy access to look at that when you arrive. If you have access to the public portal yourself, you're welcome to go and take a look at the file. If you just pull up the schedule by day and judge, you can look at the files on your own. You're absolutely welcome to do that. So you can look at the files and issue spot the day of or ahead of time. Can you skip ahead, Bradley? Thank you. So as it gets time for the hearings, defendants start to appear, we usually check in with those folks and then connect them with volunteers. So the defendant will take a minute to fill out their intake sheet, which is information. Again, I always tell folks, this is just for me. Nobody sees that. It's coming back with me. It's not going to the court. But the things that get filed with the court are the limited appearance form, the notice of withdrawal, and the pro se appearance form. We also do a limited scope retainer with our clients to outline that we and volunteers are there to assist them and represent them as their lawyer today at this specific hearing and this specific case only. And we make sure folks get a copy of that afterwards. We'll get into that. I think we get into that a little bit more later, but the retainer spells out what our services are for the clinic day. And after the hearing, if you represent someone at their rent escrow hearing, that's where your obligation ends. You don't have to do anything further with that case. The court allows you to enter your appearance and withdraw after that hearing. But our staff does follow up. We, even if it's just to call a week later and see if anyone has a question, if someone needs an answer filed, that's something that our office does. If you want to keep a case, we're not going to stop you, but you don't have to continue working with a client after the clinic day, and we will pick up wherever you have left off. You skip ahead. So volunteering on WebEx, this is something that I think it was a bit of a learning curve for us, but I think we've gotten pretty good at representing folks in this format. Didn't really have a choice, but we have certainly made it work. So if you are going to be joining us on WebEx, and I will say that with the hybrid model, let's say if only 3 cases are scheduled in Rutland, and we're not positive everyone's going to appear, it is really nice to be able to hop onto WebEx and not have to drive that far, but still be able to offer legal services to someone who may have not spoken with an attorney at all about their case. So anyway, it depends. And if we are going to be on WebEx only, we do our best to let volunteers know, and you're welcome to join us in that format too. So we log on at 10-15 minutes before a scheduled hearing. The clerks can send you off into a breakout room to discuss, privately with your client. You can ask to be brought out of the breakout room to then have a private conversation with landlord's counsel. And there's a little bit of shuffling around, but I think it pretty closely imitates what it's like in real life, where you're having multiple conversations with your client and opposing counsel. If someone appears by phone, I think this might have changed. It used to have to hang up and then call the person. But now I think they're in some places, at least, you can do a breakout room when you have a litigant who's appeared by phone, even if you're using WebEx. So things are sort of slowly improving and sort of making things easier to use for folks who have to call into their hearing. And so in that case, you're not handling paperwork if you're participating in a virtual format. But in that case, you can make an oral motion to enter your limited appearance. You can make an oral motion to withdraw on the record, and that serves the same purpose as the paperwork that we usually would file. And I also ask my client to do a notice of appearance on the record as well. So I'll just have the clerk, ask. Sometimes they swear in the client, sometimes they don't. But your client will just say their name, address, and phone number on the record, and then the court has a record of that. And it makes it easier and possible for you to withdraw now that they have contact information for the defendant. So what about conflicts? So conflicts are sort of enter a different land when you are working with folks in a legal services program in a clinic. So the rule is generally that if you do not have access to sort of the list of clients ahead of time, you are not obligated to do a conflict check. So if that was, for example, a walk-in legal clinic, right? We don't know who's coming, so you have no way of doing a conflict check, and you can assist whoever walks into that clinic without doing a conflict check ahead of time. If you recognize a name, of course, you don't have to offer services to that person. And so in our clinic, we generally weren't always, didn't always know who was going to show up, but we do have access to the docket. So you do actually have an obligation, our office has an obligation to take a look at that docket and review the names of our potential clients in our database or whatever system that you use to check for clients, or for conflicts rather. Anything else on that, Bradley? Am I missing anything there? I think it's good for folks to take a look at the docket ahead of time or the morning of.
Yeah, I think that's right. You do have an obligation to conflict check the docket ahead of time if you have the ability to do that.
And I have had attorneys say, you know what, the 10 o'clock case, that name really looks very familiar to me, but I'm not sure. That's fine. You don't have to, we won't have you take that case. We will have others for you to handle. And if there's any question on your part, we can absolutely accommodate that. For malpractice insurance, so LSV does have insurance that will cover attorneys that volunteer with us at our clinic if you don't have insurance of your own. If you do have insurance of your own, LSV's insurance serves as a secondary provider. If your policy might not fully cover you, it sort of acts as secondary insurance in that instance. So after the clinic, we open up a case at LSV. We sometimes open cases ahead of time because we're doing outreach, but that's our thing. You don't have to worry about that. And then the folks either get follow-up that can consist of helping pro se assistants filing an answer or counterclaims, referrals to other organizations for help with back rent, things of that sort. And again, a volunteer doesn't have an obligation or responsibility to do that unless you decide to keep the case. But our office doesn't, we don't sort of disappear from our client's world after the clinic. We do follow-up afterwards. So what are your ethical duties as a volunteer? So we just put the rules here as kind of a handy reference point, I know everyone on this call is very familiar with them and doesn't need me to read them, but how they play and practice at the clinic is, the confidentiality rule. A clinic is not, it's not you and your client. There's a lot of people around. There are other people who have hearings that day, other attorneys. Sometimes people bring family members or friends, and it can be a busy environment, and we don't always have enough rooms for people to meet in. So it's important to be mindful of where you are and, find a private place. I mean, finding a private place is critical. If you can't find one, let us know and we can find a place for you. But it's really important to remember you're talking about, some client's confidential matter, and you need a private place to do that. The competence rule, some of you may be, feel really confident about working in eviction defense. Some of you may not. You can learn it, and this training helps you do that. But if you are feeling unsure about it, the staff at our office is there for case questions and consultation, and we can sort of walk you through what to do, bounce ideas off of each other. If we don't have a volunteer, that's what we do with each other. There's a reason why, some of us have chosen not to work alone. We kind of like that back and forth, and we're there to sort of support you as you're helping your client. And the communication rule 1.4 is to make sure your client understands all of their options and to sort of help empower them to make the best decisions for themselves. We have in every client's folder the limited scope retainer agreement, which we want to get signed in person if you are there in person. If you're not in person and working with someone on WebEx, it's really important to go through with them the retainer and explain the scope of representation. You're not this person's lawyer for the duration of their case. You're their lawyer for this one discrete hearing, and explain what that means. And don't overcommit. If there's more to be done, you can refer clients back to us at LSV, and we'll reach out to the clients anyway and connect with them in that format after the clinic. And with that, I'll turn it over to Bradley.
Thanks, Maggie. So I'm going to give you folks a brief overview of landlord-tenant law in Vermont, and then we'll go into things a little bit more detail. So here's a slide of quick citations to the statutes that we live and die by, especially at the clinic, with in particular the RRAA, the Resident Rental Agreements Act, and the ejectment procedures. And the rest of the slide goes over a little bit of things about where you find rules on habitability and things of that sort. The tenants' rights. Tenants have a right to safe and clean housing, habitability. They have the right to quiet enjoyment of their premises. They have the right to possession, to exclude all others, including the landlord, unless the landlord enters with the tenant's consent or 48 hours notice. They can't be charged an application fee when they're applying for housing. And they can't be retaliated against for requesting repairs and habitability related issues. They are entitled to a 60 days notice of a rent increase, and they're entitled to notice for termination of tenancy, and we'll talk about that a little bit more later on in this presentation. One big thing that we want to emphasize in this presentation is landlords can't force a tenant out without a court order. So even if a landlord gives notice and that notice is proper, they still need to go through the court eviction process in order to actually force a tenant out if a tenant doesn't leave voluntarily. So a landlord can't use what we call self-help to evict tenants. That includes things like changing the locks, shutting off utilities, removing belongings. And if the landlord does do these things, this is an emergency. And so tenants may call the police to get back in. And it's something that police understand how to do. I won't say that it's easy for the police to do it, but it's not something that's out of left field for the police in terms of advising your clients to contact the police and explain what's going on. Yes, and tenants have the right to be free from discrimination based on protected classes. That should be its own bullet point, not nested under there. They have the right to be treated in good faith and fair dealing by the landlord. Security deposits are handled a particular way. We don't go into a ton about security deposits here, other than when we're negotiating move-out deals and things of the sort, to remember the security deposit. But we don't go into that in great detail here. And one big thing worth noting as you're working with clients in the eviction context is that lease agreements don't have to be in writing. Many lease agreements are actually oral, and that kind of changes the rights tenants have in terms of notice. Tenants have obligations under the law. They have to pay rent without demand or notice in accordance with their written lease or oral obligations. They can't disturb other tenants' peaceful enjoyment of the property. can't damage the property or create a code violation, can't unreasonably deny landlord access, and they must comply with terms of the rental agreement, and they must vacate upon lawful termination of their tenancy. There are special situations that we won't go into great detail in this presentation, but if they come up in the clinic context, definitely grab one of our ears and we will help you through it. Because tenants have additional protections if they have a federal subsidy, such as Section 8 Housing Choice Voucher, VASH vouchers for veterans, things like Shelter Plus Care, family unification vouchers, or they're just in some kind of federally subsidized housing. Vermont has some specific rental subsidy programs like the Vermont Mental Health Subsidy and things of that sort. Those have special protections as well. And the mobile home park statute is kind of its own beast, and there it is. They have their own, there's some pretty significant differences. Briefly, there's no cause evictions in mobile home parks for folks who own the mobile home but are renting the space. And rental increases are a little bit different, and non-payments a little bit different in mobile home parks as well. One thing to keep in mind, if someone is renting a mobile home from a mobile home owner in a mobile home park, so they don't own the mobile home and are just renting the space, they're actually renting the mobile home, the typical landlord-tenant laws would apply. So this is for mobile home parks, for mobile home owners. That's complicated, so just chat with us if you have a mobile home park case. Like I said, these situations require additional expertise, and we're here to help. Again, the basics of possession. The tenant retains possession of their home until one of three things happens. The tenant surrenders possession voluntarily at the end of a rental agreement or notice period. The landlord uses the eviction process to end the rental agreement, or uses the notice process to end the rental agreement, and or gets a court order for possession, and the tenant abandons the property. For abandonment, a reasonable person would think the unit is no longer occupied full time, rent is not current, and the landlord has tried to find the tenant's intentions and hasn't been able to do that. We don't see too many abandonment issues. It's usually number one or number two. And number two here is the meat and potatoes of eviction law. Again, landlords may not use self-help to evict a tenant. All right. And I'm going to turn this over to Maggie to get us started on a little bit more in-depth process on the eviction process here.
Great, thanks. So I'll sort of talk about the eviction process, the steps that needed to be taken to properly evict a tenant. So the first step is a tenant will receive a notice terminating their tenancy, which needs to be in writing. So some sort of letter that asks them to vacate and provides the reason, or either it's no cause, you broke a rule, here's what that rule was, or you owe money. After the notice of termination includes a date where the tenancy is considered terminated. Once that date has passed, the landlord needs to serve a summons and complaint on the tenant, and the tenant then has 21 days to file their answer with the court. That timeline might be adjusted a little bit if the landlord has requested a rent escrow hearing and the tenant attends that hearing. If that happens, the tenant then has 14 days after the rent escrow hearing to file their answer. If the tenant doesn't show to that hearing and the 21 days has passed, they may be in default. So I guess a quick example would be if you got a summons and complaint and that package of paperwork included a rent escrow hearing, and your rent escrow hearing was scheduled for 24 days after you were served, you would not have to file an answer on day 21 if you attended the rent escrow hearing. And then if you attend, you get 2 more weeks to get your answer into the court. So you could file an answer, but if there's a basis to dismiss the case or raise a motion to dismiss, you can do that instead of filing an answer, or file a motion opposing rent escrow. You can do either of these also at the rent escrow hearing. Rent escrow hearings can also, you can request rent escrow actually at any time. It doesn't have to be at the start of the lawsuit. Sometimes I've heard that landlords will file a no-cause eviction case and there's no non-payment, but the tenant may stop paying rent after they've been served. And so you can request a rent escrow hearing later because non-payment has now developed as an issue in the case. So at the rent escrow hearing is also a time when you could do oral argument or perhaps file a written motion, but you could do an oral motion to dismiss at that time. At the rent escrow hearing, you know, we do outreach to some folks and people do call us for legal services, but in a lot of the times we are meeting our client for the first time at their rent escrow hearing. That's sort of the part of their case that has gotten them to show up and appear, and it may be their first time engaging with legal services. So the rent escrow hearing, you know, assuming that happens and afterwards and the case is not dismissed, then the answer is filed after that. At some point after that, there may be the need for a status conference. You know, have we worked out a settlement? Where are things here? Perhaps engage in discovery. And then a trial would be set sometime after that. Sometimes there's no need for a status conference and folks might just want to go straight to trial. It's really sort of case dependent. And after the trial, that's when a judge would decide whether or not to enter judgment against one of the parties and whether or not to issue a writ of possession. Which is a court order that actually gives the landlord the right to take possession back of the property, maybe employ the assistance of the sheriff to physically remove someone and change the locks. And again, as Bradley mentioned earlier, a landlord's not able to do that themselves. This is the court order that does allow them to do that. So going back to the notice terminating the tenancy, like I said earlier, all of those notices have to be in writing. They can be mailed to the tenant, they can be hand delivered, and our statutes haven't quite caught up to how many of us are using text and email to get our point across, but as of now, it still has to be in writing and text and emails aren't sufficient for valid notice. Actual notice means receipt of the written notice. If a landlord chooses to mail that notice, which is perfectly fine to do, there's the rebuttable presumption that the notice was received 3 days after mailing. We've given the statute there. It's also in the rules of civil procedure. So if you're going to give notice on January 1st to be out January 14th, that notice has to be hand delivered to be valid. Otherwise, you need to give notice till January 17th if you're going to put that one in the mail to give the person enough time to get the actual 14 days including the 3 days allotted for mailing. And it's the landlord's burden to prove that that actual notice happened and that the tenant received it. So how much notice is required? It depends on a lot of factors, and that the main factor that determines how much notice you need to give is the reason why you're evicting the tenant. If you're evicting somebody for non-payment of rent, it's 14 days notice generally. That example I gave earlier is for non-payment of rent, but it's 30 days notice if the property is subject to the CARES Act. The CARES Act went into effect in 2020. It has not gone away yet. We're still working with parts of the CARES Act. And so 30 days notice is still required if the property is subject to it. We've provided links to the CARES Act to figure out, you know, if that's something that's applicable. And the CARES Act certification is on the judiciary's website. So if a landlord needs it, it's right there. It's available for them to access. Violations of the lease, so for-cause eviction is 30 days notice, but it's shorter. It's 14 days if the allegation of the rule violation is for dangerous or criminal activity. For no cause, no cause is if there, again, I always have to look at the statute. Don't feel bad. I've been doing this for years, and no cause still trips me up because there are so many different amounts of time that could be employed, and it depends on if you've got a written lease or not. If there was no written lease or the original written lease expired without renewal, or it has not converted month to month, and the lease would say which one of those things has happened. If there's no written lease and the person has lived there for 2 years or less, 60 days notice is required. If they've lived there for more than 2 years, then 90 days notice is required. If there is a written lease, then 30 days before the expiration of the lease is the notice required for a tenancy 2 years or less, and 60 days if it's been more than 2 years of a tenancy. So that I already feel like I'm reading it, my head is still swimming. So don't feel bad if you have to look at the statute. I still do every time. And of course, in Burlington, the city ordinance gives even more time for these scenarios. It's generally an additional 30 days for each provision, but if you have a property that's in Burlington, just refer to the city ordinance so that you can see if the appropriate amount of time was given, and refer back to the statute and never feel guilty for having to do that. And if the property is sold, that's also 30 days notice, as long as there's no ongoing lease for a term. Oh, look, there's the Burlington specific protections. Okay, so you can look this up on your own, but generally that no written lease provision is a 90 days notice if someone's been there for less than 2 years, and 120 days notice if the tenancy has lasted for 2 or more years. So, I mean, that's quite a bit of time. That's almost 4 months of notice. So it's really important to know what's required if your tenant's in Burlington. Rent increases in Burlington have to be 90, you have to give 90 days before the rent increase goes into effect. That notice has to be in writing. For the rest of the state, it's a 60-day notice of a rent increase, also has to be in writing. The security deposit, has to be held in an interest-bearing account. I come from Massachusetts, where that has been the case for a long time, but I think Burlington's the only state that, or city, sorry, that requires that here. And that interest has to be paid to the tenant at the end of the tenancy. And the security deposit, and this just in Burlington, it's not for the whole state. The deposit may not exceed the amount of 1 month's rent. I guess I have seen people try to charge more on a deposit, but anyway. So if your client's in Burlington, just be sure that you check the city ordinance. So there's a lot of common mistakes that can pop up when a landlord is giving someone a notice to quit. And there's a lot of, Bradley and I say this a lot when we give these trainings. This is it can be a highly technical area of law. There's a lot of rules. The good news is those rules are not a secret. They're in the statutes, easy to find them. But if you're not sort of being careful about it, it's easy to miss something. So notices have to state a specific termination date that is at least the correct number of days after the date in the notice. So in other words, you couldn't say something like, I'm sending you this notice on January 1, and you need to be out in 14 days. You have to then say, and you need to be out on January 15th, or actually say the date. In a non-payment case, those notices also require that there be a redemption clause. So you have to tell the tenant, if they owe rent, how much do they owe? And when you're telling them what they owe, you can only indicate the amount of rent that they owe. You can also mention, maybe there's some other bill or utility that they're behind on if they're responsible for that per the lease. But they need to be told that they can cure or stop the eviction from proceeding by paying what they owe. And you can redeem by paying rent. You don't have to redeem by also paying utilities or whatever else might be alleged. If the tenancy is subsidized, the notice to quit also has to be sent to the subsidy provider contemporaneously, at the same time as the tenant, in order for there to be a valid lease termination. So usually you can see that on the notice to quit. You might see at the bottom a CC to Vermont State Housing Authority, so then you know that the Housing Authority got it at the same time. Sometimes when that is not present, I'll check the complaint, and the complaint may allege, we sent this notice at the same time that we sent it to Vermont State Housing Authority. But the Housing Authority is a party to the lease. They also have a contract with the landlord as well. And so if the tenancy is terminated only with the tenant and not to the Housing Authority, then the lease has not been properly terminated, and the court doesn't have subject matter jurisdiction to hear the case. So we'll talk about that a little bit later, but that is a pretty common error. And also, a lot of my clients get the notice to quit, and, even though you don't have to leave, right? The only person who can tell you to leave and you have to do what that person says is a judge. But the way some of these notices are worded, they sound pretty serious. Like you have to leave on this day and there's really no two ways about it. But even though the letter might be worded that way, a landlord can't force somebody out on the termination date. That is the date that the tenancy has terminated. The landlord has made it clear that, we don't want you here after this date. But if the tenant remains, then, and the landlord still wants to go ahead with getting their client evicted, or sorry, their tenant evicted, then they have to move on to the court process in order to get that result. And Bradley, I think the next slide is yours, right? Yeah, it is.
Yes, it is. All right, so I'll talk a little bit about the other steps, including the summons, complaint, and initial service. So a landlord may file eviction paperwork and serve it to the tenant to start the eviction process. The initial service has to be done by the sheriff. So it's called Rule 4 service, and all other papers may be served personally, by mail, or some other means per agreement of the parties, called Rule 5 service. Tenants have 21 days to file and serve their responsive pleading. It's usually a motion to dismiss or an answer, unless there's a motion to pay rent into court that they're served with, in which case that extends the time that they get to serve the responsive pleading until 14 days after the rent escrow hearing if they've not previously defaulted. There are the words "if they have not previously defaulted." Those words are in the statute. Most judges, actually all judges I've seen address this issue, say that you can't get a default before if there's a pending rent escrow hearing scheduled. Some attorneys have filed for defaults while a rent escrow hearing is pending because the rent escrow hearing was more than 21 days. And I have not seen a single attorney be successful in that. In fact, I saw one recently been denied just the day of the rent escrow hearing because the filing was premature. That tenant didn't show up. So, then the landlord may choose to file a new default judgment after the fact, but they just, wasted their time. But that language is in the statute, and that is something that opposing counsels may bring up to say that your client is in default, and that is your response, that the law gives tenants an additional 14 days to answer. So the summons must include, or must have attached to it, the following things: the name and address of the court, the name, address, and email of the attorney or pro se landlord, the time in which a defendant must respond, a blank notice of appearance form, a blank answer form, and a warning that failure to answer could lead to default. A lot of attorneys, so ironically, pro se clients, pro se plaintiffs don't have this problem because they get the summons from the clerk. But attorneys, we do the very bad thing of relying on our forms. And so some attorneys were using outdated summons that only said 20 days when the rule changed to 21 days, I think in 2018. And that is grounds to have a 12B4 motion to have your complaint thrown out. So if you're on the plaintiff side, make sure you get your 21-day summons. And if you're on the defense side, make sure that the plaintiffs have their 21-day summons. And the blank notice of appearance form and blank answer form also have to be attached. And it has to, and this is Rule 4 service, right? So this is service that's done by a sheriff. And so many attorneys will, and as we do, we rely on our forms and the way things have been forever. Won't always stay on top of changes in the law, and so may forget to do a blank answer form, which was fairly new. It's Rule 4 service, so it has to be done by a sheriff, and so a lot of attorneys might think that they could cure that in the courtroom or something of that sort, and they actually can't cure that in the courtroom unless the tenant chooses to do that and waive their right to Rule 4 service. And if a tenant waives the right to Rule 4 service, they actually get an expanded answer period of additional 60 days, which landlords usually don't like. So those are just things to keep in mind. That's why we emphasize service by the sheriff, and that is meaningful to judges because a lot of these things tend to be little onesie-twosie, no harm, no foul kind of issues. But the law is the law in terms of what the sheriff actually needs to deliver. And I think Rule 4 service is more, I wouldn't say more important than other kinds of service, but it's the most important service because it notifies the tenant of everything from the get-go. And kind of without that solid foundation, they might not be able to exercise their rights accordingly. The complaint must state the grounds on the eviction and the relief sought. The grounds must reflect what was noticed. Sometimes the grounds don't reflect what was noticed, and that's a great motion for motion to dismiss. And no attorney's fees unless they're provided for in a written lease, or an eviction is being brought due to serious material breach of the lease, i.e. not non-payment of rent, right? So this is, if an attorney is seeking attorney's fees and there's no written lease, or the written lease doesn't provide for that, they're subject to a motion to strike. And that's a great way to get rid of those superfluous fees and just to kind of get rid of those superfluous fees. And before I go on, we didn't talk about questions, but if you have questions, Maggie is monitoring the chat. Or if you feel comfortable speaking up, just speak up. Just be mindful that the hearing is, this presentation is being recorded, so please don't say anything confidential about your clients. But if you have questions, feel free to ask them as we are going. So in addition to the stuff that every plaintiff needs to do, plaintiffs in eviction proceedings also need to put to attach a copy of the written lease and a copy of the notice terminating tenancy to their summons and complaint. Due to COVID, courts acquire additional paperwork. So all evictions must have a declaration of compliance with the CARES Act, that's codified in the Vermont Rules of Civil Procedure. And then evictions for non-payment of rent must have a notice, Appendix D, VRAP notice of tenants, if the eviction is filed before September 30th, 2022. And we're almost at the point where we're not dealing with those evictions anymore. I think like a handful of them are scheduled in Chittenden tomorrow, but we're almost at the point where all the evictions that we're dealing with have been filed after September 30th. So rent into court, the hearing itself, again, the landlord has a right to request a court order that the tenant pay rent to the court clerk directly while the court process is ongoing for an eviction, not just for non-payment. This request is called a motion for rent escrow. It can be ordered. The rent can be ordered from the date of service or the date of filing, whichever is earlier. So some attorneys initiate a case by service. For the most part, people initiate cases by filing. Rent can be ordered from that date, not the date it was noticed, which could be a lot earlier, and not necessarily the date of the rent escrow hearing, but we can negotiate things, and we'll talk about that a little bit later. Rent escrow hearings are just about the money. So there's substantive legal issues, maybe with the exception of habitability, and we'll talk about that, aren't brought up. And the judge does not rule who gets possession at a rent escrow hearing. It's just about whether the tenant is, one, obligated to pay rent, and two, has failed to do so until that point. And some courts will consider habitability related defenses at rent escrow. So if the tenant is saying that my water heater doesn't work, so I don't think I owe the entire amount of rent, a judge may order less rent into court. I have almost never seen a judge order no rent into court based on habitability concerns. Not for lack of trying, but I have seen some pretty serious habitability concerns come through, and the judge still orders at least some rent into court. So just keep a heads up on that. Rent escrow is also an opportunity for parties to reach an agreement. Maggie will talk about that in a little bit. And if the tenant is ordered to pay rent to court but fails to make that payment, then the landlord can request a 5-day writ of possession for failure to pay. And that's an automatic grant. If it turns out that the tenant did not pay into court as ordered in the rent escrow order, the landlord just calls the court, the clerk says they haven't paid, and then the landlord files for that writ. And the judge, as soon as the judge gets to it, the judge will grant the writ.
Bradley, I'll just hop in and say I did see no rent ordered one time, which was when my client was actually displaced because a pipe had burst and the apartment flooded, and the pipe bursting was not her fault. And so she had to access emergency housing, had the health officer order that said it's not safe to live here. And that was the one time I saw no rent order due to habitability.
Well, that's good. That's good.
And it has happened. That's all I'm saying.
That would be an absurd situation to have to pay rent in a place that you can't live in.
You can't even live there. You've been ordered out, right?
Yeah. So okay, so it is possible. It's I think in more common situations, it's a tough sell, but it is possible, and that is definitely worth discussing with your client. And so, and just briefly after the rent escrow, this presentation is designed, it's, at the 10,000 foot level, and then we just kind of funnel it down a little bit. So we'll go into more depth on the rent escrow presentation, the rent escrow piece in just a moment. But after the tenant answers, the court will usually schedule a status conference or a merits hearing. Sometimes they schedule the status conference at the rent escrow hearing, or even the merits hearing right at the rent escrow hearing. The landlord will get possession if the tenant doesn't answer, the tenant misses a rent escrow payment, the landlord wins at a trial, or there's a move out deal or stipulation. And the writ is executed no less than 14 days from service of the writ, unless it's 5 business days for missed rent escrow payments. And I think it's 14 calendar days from service of a regular writ, but 5 business days for missed rent escrow payment, unless I'm wrong about that, Maggie.
I think you're right about that.
Okay.
You're right.
And writs must be served on the tenant in person by the sheriff. All right, and Maggie, I'll turn this over to you for rent into court basics.
Yeah, so I'll talk a little bit about, when you're actually volunteering with us, kind of what do you need to know, what can you work out, and what's possible at a rent escrow hearing. So when you're at a rent escrow hearing, the landlord and their attorney are usually looking for a payment of rent into the court. But how much rent can they get, right? Usually someone may owe many months or not that many months, but the amount of rent that they can get is the amount of rent that has accrued from the date of filing or the date of service, whichever happened earlier. And it's good to kind of know, sometimes even before I start talking with my client, I might do a quick calculation just to figure out how much that is, like how much rent does the statute give the landlord today, just so I kind of know what I'm working with. And so things that you may want to think about is, whether or not anytime the parties are together is an opportunity for something to be worked out, for people to communicate, figure out where the other side's coming from. And that always can maybe lead to settlement, right? So it's possible to get a settlement of the entire case at the rent escrow hearing. In the days where we were using VRAP, that was a really excellent tool where we could get our clients sometimes entirely caught up in rent. VRAP paid up to 18 months of arrears and future rent. So in maybe some limited circumstances, your client may be eligible to tap into some of that money, but that benefit is, as time goes on, it's just not as available to us anymore. But, it could settle with, payment, a way to access payment. If the eviction is for no cause, some landlords may want to settle with, either a payment, sometimes a waiver of back rent in exchange for a move out date. And, I often say that it's really important when you're reviewing a file and getting ready to talk to your client, you might find something kind of juicy in there, like a great motion to dismiss that you have a really strong likelihood of winning. But if your client says something like, I have plans to move out in 5 days, I have a new apartment lined up, I'm ready to go. Okay, maybe it's a different conversation. Maybe it's not a discussion about, let's go ahead and get this case dismissed. maybe you're going to opposing counsel and saying, look, can we work something out here? Because your client's getting ready to go and they have their own set of goals, right? And their own things that they want to get done in their case. Something else you can figure out is, once you figure out what the statute would mean in terms of a payment from your client, you can also see if the plaintiff is willing to stipulate to a rent escrow payment. It could be that your client owes 2 months of rent and they're not going to be able to make that payment when rent escrow would be due, 5 business days, generally a week after the rent into court hearing. But they could make that payment if it was 2 weeks out. So if, the landlord's goal is, I just want to get paid, I'd really like this rent money, then you can maybe suss that out and say, we can do that. We just need a little bit more time. And maybe you agree to a rent escrow order that sort of deviates from the statute a little bit, but the parties agree for a slightly later time just to make sure, and so that your client has the ability to make the payment and get it in. VRAP, I think VRAP is only taking requests to pay rent into court until November 30th. So that's really going away quite soon. And when we had, the ability to access VRAP, we were frequently getting rent escrow orders due 30 days out just to give, VRAP enough time to sort of have an application go through its system. And that could sometimes take a while. But anyway, that's something that's kind of going away. And as Bradley mentioned earlier, if there's a rent escrow order that's issued by the court, the consequence of missing that payment is issuance of a 5-day writ of possession. Sometimes I've been in the really sad situation where a landlord and their attorney may not be willing to negotiate anything. And my client owes a lot of rent and rent escrow is going to be due in a week and it's for an amount of money I know my client can't pay. Those are really tough situations, but it does happen sometimes for a variety of reasons. And it's really important for your client at that point to at least have the knowledge what's going to happen and when. And I usually tell my clients in that case that you should plan to be ready to be out 10 to 14 days after the missed payment. It kind of depends on a couple of things, right? How quickly is the landlord going to write their motion for a writ of possession? How quickly is the judge going to look at that? How quickly is that going to get sort of variables that come up in terms of timing? But I usually tell folks to expect you have 10 to 14 days after the missed payment to plan that to be out by. It's just good for people to know that so they can make the best plans for themselves and their family. So for a landlord to get a rent escrow order, they have to make a motion with the court for that. That has to be accompanied by an affidavit that's signed by the plaintiff. As we talked earlier, a landlord can request rent escrow at any time. The majority of them, I think, do it at the time of service. They ask for everything at the same time, but it can be filed at any time. It doesn't have to be at the start of the action. So again, it's often filed, then served along with the summons or shortly after that. And tenants have to get 14 days notice of a rent escrow hearing. There's really no two ways about it. I had a case a couple weeks ago where my client only got 2 days notice of the rent escrow hearing. I'm not really quite sure what happened, but the judge rescheduled it. And there wasn't much of an argument from landlord's counsel because the hearing has to be rescheduled. People need 14 days notice. The rule is the rule, but the thinking behind that is that if you're going to have a rent escrow hearing, you need some time, and the statute gives them 2 weeks to get your ducks in a row, to start to make a plan for how to potentially make the payment that you're about to be ordered to pay. And that's not for nothing. That time is really important, and defendants are entitled to it. And as Bradley mentioned earlier, a motion for rent escrow can be filed in any eviction, but you can only request rent into court if the tenant is actually behind on rent. Another side thing, which might come up later, is you can also only get a rent into court order if the tenant still also lives at the property. That's also a request. If they have moved out, you can't get a rent escrow order for someone who is vacated. So So when you're meeting with your client, as I discussed earlier about, discovering that really juicy motion, it's always kind of exciting when you find that you have a basis to request a motion to make a motion to dismiss, and you might get the entire case thrown out, and that might be a great thing for your client. But it could be that that's exactly what your client wants to do, but it's really important to get a sense of where your client is, what they want, and what their goals are. Do they even want to stay in this apartment? Are they looking to move? Are there habitability issues that are ready to be raised today? And by ready, Bradley and I mentioned earlier that, notice has to be given to the landlord of a habitability issue. If let's say, the toilet is, consistently leaking and not flushing, but today is the first time that the tenant has mentioned that to anybody. The judge, judges are generally not that sympathetic to issues where, a landlord can't solve a problem that they haven't been notified of. So if the landlord has gotten notice of that issue, your client has evidence of that, you may be able to proceed with habitability defense to rent escrow, but the majority of time, I don't think they're quite ready yet, largely because notice hasn't been given to the landlord. But it's worth discussing if your client mentions a habitability issue. You also should find out if your client actually owes rent. Folks get 2 weeks notice, but a lot can happen in that time. Maybe they've made some payments in the meantime, and they've covered the amount that has come due from the date the complaint was filed until now. Are those amounts correct? Another thing that can sometimes be a difficult conversation, sometimes not, is can your client actually afford this apartment? Bradley referenced earlier that a lot of our clients receive benefits and are on a fixed income. And, generally 30% of your income is considered an affordable amount to pay for a housing expense. But if you are talking to a client, and I've seen this before, where someone is paying 50%, 70%, 80% of their income on just their housing, that one bill, it may be time to have the discussion of, is this affordable? Even if you can sort of get caught up, is this affordable in the long term? Is this rental situation really make sense long term? And if it doesn't, maybe discussing a settlement to get them out of that really expensive situation makes sense. Talking about whether or not the rent escrow order of any amount is going to be affordable. Does a payment plan work or not? Those are all things that are important to talk about with your client when you meet with them. And so sometimes there are two defendants that are named in an eviction case, and we talked about conflicts earlier, but sometimes those co-defendants are actually adverse to one another. You may have defendants who are a married couple who are in the process of divorcing, or roommates who have maybe one has an RFA against the other, or they blame the other one for the rent not getting paid. Those are all situations where the defendant's interests are adverse to one another, and we're not able to help both of them. So the way that we handle that is that we represent the person who came to us first. So it could be the first defendant who walked into court that day. That's the person that will help. It could be that one defendant called us looking for legal services ahead of time. That's going to be our client. If co-tenants are not adverse, and a lot of the time they're not, and people have the same goals, they're looking to keep their apartment together or not. But if things are tenuous, and sometimes you may be able to tell that, you could consider getting a written conflict waiver from those clients at the outset, if you have co-tenants that you're assisting both of them. So common rent escrow situations. I gotta say, this slide I don't really use it a lot in the era of VRAP, because VRAP would pay, but now that we're losing VRAP, this sort of comes back into play a little bit more. But doing this work for quite a bit of time, there were sort of a few common situations that cases fell into certain categories. And as we sort of say, the fact patterns can certainly vary, but largely they sort of break down into these groups. The first one is, your tenant's just not able to pay for the apartment. It's not affordable. they're making a rent payment that's way more than what their income allows. It might have been a reach at the time, but given the market, people are taking what they can get and sort of worrying about affordability later. So it was so nice to offer VRAP and say we can get this person entirely caught up. That was great. But without that, options if the place is really just not affordable or is not going to work long term, an option there is to just get into some type of rent escrow order and until your client can come up with a plan to move. When I'm talking to my clients about that, I explain it as you're quite literally buying the time in this apartment until there's a final hearing or until the judge makes a decision or until you find a place to go. If they're not prepared to move out, if they're not prepared to settle, getting into a rent escrow order so they can just make those payments and retain possession until there's a final hearing, it might be the best thing and gets them a few extra weeks that they might not have normally had. Another scenario that your tenant can pay rent, but catching up is going to be hard. A lot of our clients, on fixed incomes or not, I mean, a lot of my clients who are working may have, incomes that are just low enough so that any sort of financial upset is going to set them back in multiple areas. It could be, a necessary car repair, gas bill that's super high at the start of the cold season, illness, something like that can really set somebody back. And not a lot of people have savings or a safety net that's going to be there when things like that come up. So if catching up is going to be hard, we do refer folks out to community action organizations. A lot of those places, we're sort of getting tapped back into those now that VRAP is getting phased out. But a lot of those groups will pay something like 3 months of back rent. Some of them will pay the court costs. So it's worth looking into those options if this is just a financial setback, that some help may be what it takes to allow your tenant to stay. Another solution is, if catching up is really difficult or maybe impossible, then again, a stipulated move out date in exchange for a waiver of back rent or any other claims against your client might be the best thing for them. But these are all, and as I go through these situations and solutions, the solutions are really to be presented to your client as options, right? They should be fully made to feel like it's their choice, right? Because it is their choice. It's their life. It's where they live. It's their case. So these are all things that you can lay out as these are the things that you can do. Here's what I think might make the most sense, but it's up to your client to choose the course of action that they want to take. A lot of our clients have rental subsidies. So VRAP certainly was, it was paying for folks that had rental subsidies, but folks with a rental subsidy were one of the first groups kind of off the program as VRAP started to get phased out. But it's really important for if someone has a rental subsidy that rental subsidy be protected. If it's a subsidy that can be taken from one apartment in the private market to another one, it's important to do what you can to preserve that subsidy so that someone can use it in another place. If you have any questions about that, it's really great to come to us and just talk to clinic staff about, this person is a subsidy. I'm not quite sure what the best thing is to do, and we can talk it out. It's great in those situations to also discuss getting a neutral reference or a neutral landlord certificate. That's the required paperwork to move with a subsidy, to sort of make it the easiest transition for your client where they can retain the subsidy or the voucher at the next tenancy. I've also seen in rent escrow, I've had folks show up and they've told me, I've already left. I'm gone. I don't live there anymore. And, maybe they moved out, in the 2 weeks notice that they got for rent escrow. Maybe it was earlier than that. But if they've already gone, then it's worth kind of, talking to the tenant. What are the remaining issues, right? Possession's already been resolved. They're gone. The landlord has possession back, or in theory is going to get possession back if they've left. But the last issue to resolve is who owes who what, right? So if your tenant's already out at the rent escrow hearing, that tenant's kind of expedited things a lot for the landlord and has kind of made their job a lot easier, made the case a lot simpler. So asking for a waiver of back rent is a great thing to request in that situation because things can get buttoned up really nicely if the person's already left. Okay, so negotiating with opposing parties. We've gotten, I think, the chance to get to know a lot of landlords counsel over the years, and generally, I think we have pretty positive relationships with them, and it can make everyone's job easier when there's a lawyer on both sides. So in negotiating with the opposing party, it's either going to be the landlord or it's going to be opposing counsel, is something that once you've kind of figured out what your client wants, a sense of their goals, what they're looking to do, it's time to sort of check in with the opposing side to see what's going on their end. It was very nice asking for a postponed rent escrow order with VRAP, but that's, as that's coming to a close, again, negotiating the timing and amounts of rent escrow is, something I did very consistently as a part of my practice before the pandemic and before the VRAP program. If rent arrears are really high, it can be hard for a landlord to actually get any of that money back, right? Let's say, in my time, I've seen arrears as high as, $20,000, and that can sometimes be an impossible amount. So, you could ask if the opposing counsel would consider some sort of deal that includes a move out, a waiver, VRAP application, if at all applicable, especially with the high arrear cases. But if we're not able to work something out, if we're not able to present the judge with a stipulated rent escrow order or a stipulation that dismisses the entire case, sometimes contested hearings are necessary. And those contested hearings can look like going ahead with a motion to dismiss. It can be the habitability issue. It could be a contested hearing about proper service, right? If your client's alleging that they weren't served properly, you may have to put on testimony about what happened there to make that point to the judge. I would say contested hearings are certainly not off the table, but I think we don't see a whole lot of them because we're generally able to work things out with opposing counsel. And I think Bradley's going to pick up with reviewing the court file. I will also say I can see the chat. You can also raise your hand, or if you want to, pipe in with a question, you're welcome to do that at any point.
All right, so I'll go over some reviewing the court file for defects. We have about 15 minutes left in our presentation. We'll probably go a few minutes over, and if you can't stay, we will have this posted on our website. And we'll have links to the different sections that'll follow along as well. So just a heads up on that. Again, a refresher on the contents of the court file. So the notice to quit is usually the first thing that you're going to look at outside of the summons or complaint. And sufficient time in the notice is probably one of the most important things that you're going to look for in terms of substantive defenses. And so was there sufficient time? Was there 3 days given for mailing? Was an actual date specified? Amounts other than rent included in the redemption amount? The redemption clause is not there at all. So you want to make sure that the notice for a non-payment has a redemption clause. If it's for cause, is it specifically described in a notice? If it's no cause, we have a chart for the timing of that we'll hand out to you folks. If you have to leave, just put your email address in the chat. Otherwise, at the end of the presentation, we'll ask you just to put your email address in the chat. Then we'll know to send you the materials. Here's a defense of the Fair Debt Collection Fair Debt Collection Practices Act. Basically, this is a cause of action that clients have against the attorney if the attorney issued the notice to pay rent or quit, but did not identify themselves as a third-party debt collector. Every now and then we'll use this defense. We'll notify the attorney of this possible defense. It's not a defense to the eviction. It's a claim against the attorney. And the attorney may choose to issue a new notice because they are in compliance with this federal law. If they don't, there's up to $1,000 in statutory damages, and clients can make complaints, consumer complaints, to the federal, really the appropriate federal agency, and receive up to $1,000 in statutory damages. So that's just one thing to keep an eye on. There's some standing problems. So sometimes the plaintiff, the landlord, has to actually be the owner. So sometimes the plaintiff is not the legal owner, or the legal representative of the owner. Sometimes they're an unregistered corporation or company. They're trying to evict the tenant from the wrong address, or plaintiff is a corporation that's not represented by an attorney. That comes up pretty often. And there's some strict exceptions to the rule that each case has to abide by, and we're happy to discuss that with you, and whether that's an appropriate defense. Sometimes judges are not sympathetic to corporations, LLCs being, or corporations or LLCs that are represented pro se. Their courts tend to be sympathetic to those folks. But if they've made a number of other errors, I tend to bring that up as a reason why corporations and LLCs need legal representations, because they have to follow Vermont law. This is actually fairly technical. Some motion to dismiss arguments here. There's no notice to quit, or the basis alleged in the complaint is different from the notice to quit. The notice to quit didn't provide enough time. It doesn't provide the right to redeem. The redemption amounts include things other than rent. There's the for-cause notice is insufficiently specific. The notice didn't comply with federal regulations. Those are just some common motions to dismiss. Another common motions to dismiss, these are no cause. So you can't no cause a termination, or give a termination for no cause during the term of a written lease. And no cause is not legally permissible unless it's otherwise stated. Some landlords' attorneys believe that you can terminate a tenancy within the term of a written year lease, so at month 6 of a year lease. I haven't seen one be successful, but there is some case law out there that suggests that they may be successful if the written lease is written in a certain way. So it's definitely something to chat with us about. But for the most part, we say no cause. You can't no cause evict someone during a term of a written lease. For non-payment of rent, the rent was not owed or was already paid. That has come up quite a bit with VRAP. Maybe not so much moving forward, but that did come up quite a bit. And some common for-cause defenses. Another defense for no cause is what happens when and it's not written here, but what happens when a written lease expires. Sometimes written lease convert to month under the same terms. Sometimes written leases just renew themselves on a yearly basis, and sometimes written leases convert to a tenancy at will, right? And say no holding over. It's very specific. So what we often advise is that you review the written lease specifically, because if someone is being terminated and their written lease expired a long time ago, as you saw, different amounts of time in a no cause case are required if you have a written lease versus if you don't. And so just because a written lease is filed doesn't mean it's still legally valid. Often we'll see landlords' attorneys filing a written lease and only giving 60 days notice when 90 days would otherwise be required. You examine the terms of that lease, and it says that if the tenants hold over without written permission, the lease expires and it creates a tenancy at will. And in which case, that means there's no written lease for notice purposes, and they actually are entitled to 90 days notice. That's super complex, but it's one thing to keep an eye on, and that's a fairly common mistake, because I think a lot of leases are written such that landlords didn't want tenants staying after the term of the lease expired without a new lease. But oftentimes I think people just kind of get in the habit of accepting rent, which is common. So you need to keep a careful eye on whether or not a written lease is actually still valid, even if the plaintiff is alleging it is. The landlord files in a county other than the county of the rental unit. That's a 12B3. Don't see that too often. 12B4 arguments, these tend to be service-based arguments. They will be waived, or at least I argue that they are waived if you don't raise them at the rent escrow hearing. And landlord failed to attach a copy of the written lease or the HAP contract. There's no blank answer form. The summons is defective. There's failure to serve the care certificate or the VRAP Appendix D. You might be able to argue that these are not waived under some other 12B argument, but I think they fit more logically under 12B4, which does waive at your first appearance. 12B5, tenant was not served with summons and complaint. So kind of the takeaways up until this point is that the filing defects are a powerful negotiating tool. If you notice one of these defects and your tenant has some options, that's great a negotiating tool to negotiate waiver of back rent and a move out date, or, excuse me, to give your tenant some time to get caught up and maintain the tenancy. Things of that sort. It depends on case by case situations. But identifying these defects can really empower your tenants to give them some negotiating room when they ordinarily might have thought that they did not have that negotiating room because they know, oh shoot, I'm behind 3 months on my rent. How am I going to do this? And it turns out they might have a defense and a place to go. They just need a couple more months to kind of get that together. And you can kind of empower them to make those choices and to kind of advise them what their rights are. One thing that we were frustrated by is that many landlords are not interested in allowing their tenants to stay after they've had to file an eviction, even if they are being paid by VRAP. The Vermont law does allow landlords to terminate a tenancy for no reason, even if tenants are fully paid up on rent. Always advise your client fully. Options to dismiss, delaying proceedings, potential next steps. And sometimes delaying a dismissal are the only options in a no-cause eviction if your client doesn't have anywhere to go and they would rather just extend the process for as long as they can, knowing that they won't be able to find a place to go anytime soon. All right, Maggie, I will turn this over to you, and it is 2:25.
Okay, I will try to take it home in 5 minutes. Well, we may go over, I guess, a couple minutes, but I think we can probably, I was looking ahead. A lot of this we've covered largely, so I think I can go quick through it. So we're going to talk a little bit about sort of, concluding the case. So we did talk a little bit earlier about habitability complaints and sort of the difficulty with raising that at rent escrow if the claim hasn't sort of been properly documented, if there's no evidence of that. And the seriousness of the problem also may impact whether or not it warrants a reduction or of rent into court or no rent into court. If there's a toilet that's leaking, is that really affecting the health and safety of the tenants continuing to live there? If there's no toilet, yeah, like I would say that's a huge deal, right? But there's a big difference in those two claims. If you do decide to go ahead with a habitability claim at the rent escrow hearing, again, it turns it into an evidentiary hearing and the judge will consider that. But it's also important to be ready to tell the judge what you actually want them to do, right? If it's a kind of serious issue, I would come right out and just say, I think this warrants a 25% reduction in rent, a 50% reduction in rent. Like, tell the judge what you're looking for. Don't make them come up with the solution. It's good for them to kind of have the roadmap that you set out. Let's go to the next slide. I guess one final word on that, though, is that if there's a habitability claim that's not ready yet, I always tell my clients this is an issue for the final hearing, right? It's not that this can't ever be considered. It's just not an issue that's ready for today, but we can come back to it. So for settlements, if we want to try to keep our tenant there in the rental unit and they want to stay too, things that we sort of consider are, if there's no cause, there's not a lot of defenses to no cause. So sometimes it's important to ask, what is the reason behind that, Is there a reason that the landlord is willing to articulate about why they want this person out? And can we explore options instead of continuing the tenancy? I have a client that was about to be no-caused, and it came up that they were just frustrated that rent was continuously late. Like, why do we have to wait so long? And so we resolved it by offering a direct deposit from my client's account each month, and he's getting to stay. So that's one example of sort of rooting out what's really behind a no cause and leading towards your client actually being able to keep their apartment. For cause, just a word of caution that sometimes cause or a rule violation, it could be the result of your client's disability. And so it may be also worth exploring if a reasonable accommodation for could that cure the violation? Could that be what it takes to actually come up with some sort of solution, maybe an outside of the box solution to that problem so that the tenant can actually stay. And if they're able to cure that problem, will the landlord be, satisfied enough to allow them to stay? For non-payment, as I always tell my clients, the thing that solves non-payment is payment. And, VRAP can do that for a limited time. So can community resources. And if none of that's available or if that's not sufficient, sometimes repayment agreements are the way to go. So if you are able to come to a settlement at the rent escrow clinic, which does happen a fair amount of the time, we draft those that same day. We have templates that we use and we've handwritten them. If you're on WebEx, it's something that you might be able to draft at your computer and then email to the clerk so that the judge can review it and sign it. But it's important to address sort of these big items. If there is a move out date that everyone has agreed to, it's important to specify that move out date and the date that a writ of possession will be valid. Just a word to the wise, most sheriffs are not going to be executing writs of possession on the weekend. And if you want it for a time later in the day, say that, because I think if you don't specify that, most writs are going to be executed first thing in the morning around 9 a.m. If everyone agrees your client can have until 5, you should make sure that that's a part of the order. How is the writ going to be served? If everyone's in person, the tenant may be able to accept service that day. If not, is the attorney going to accept service? How is it going to be served on them? That just should be addressed in the document. How is your client going to leave the unit? I generally say broom clean and free of debris. What's going to happen with the keys? Are there going to be payments that are going to be made into the court? And, I will also say that some judges don't want the court to be accepting rent escrow payments when there is a move out agreement. So that's just something to be aware of. Maybe you find some other way to address rent payments between the time that you're in court and by the time that there's the move out day comes. But it sort of depends on judges. We're always happy to talk that out with you. Can you skip ahead? Thank you. So we just put in kind of a sample non-VRAP settlement. So this is a good reference to sort of look at what we do. It's pretty, they're bare bones, but they're quite straightforward and they do include everything that needs to be covered. So this is just an example of what we use. And so settlements can also, for VRAP settlements, they can include court costs and attorney's fees if the written lease provided for those attorney's fees. And again, VRAP is only accepting uploads of stipulations for those fees until November 30th. I have a few that I need to get done between now and then, but the time on that is quickly running out. If you're stipulating to rent escrow, we talked about this earlier. You can, if the landlord and their attorney are willing to agree to this, you can negotiate the amount that's due. You can try to negotiate the date that the first payment is due into court. I've asked for, if my client owed 3 months of rent, can we just pay 1 month due next month and then rent going forward while we work out some other type of arrangement? And if you can get that, it's always in your client's best interest if they're going to do a rent escrow order to get into an order that's actually accessible, a payment that they are actually able to make. Sorry, just one last thought on that. The courts do have plaintiffs bring orders to court with them. And we do have forms available too. Sometimes courts will generate their own, but that's not really consistent. Plaintiffs should have a draft order ready to go. And you can also contest rent escrow. A lot of the time, we've talked about this based on habitability, based on rent, being paid. There are ways to oppose it. When we're in the clinic setting, generally we do oral motions to oppose rent into court. But if you're going to do one in writing and you have some time in advance to do that, you draft a motion opposing the rent escrow motion, and you have to include a supporting affidavit from your client. Arguments that you can also make at rent escrow to essentially indicate that rent escrow should not be ordered by the court are as if there's a motion to dismiss, and that has to be decided first before a rent escrow order can be issued. That the premises is not worth the rent that's owed. That's a habitability claim. Another argument could be that, the tenant rents there, but they for some reason don't have access, that there's been an illegal eviction. That's a reason to oppose rent into court. That the tenant doesn't actually owe the rent. They've paid and that they have or will apply for VRAP. I guess at this point it just has applied for VRAP. But that those are all ways to sort of push back against that order. As we've gone over, if your client attends rent escrow, they have 14 additional days to answer after the hearing. We generally contact folks afterwards to help them with their answer. Sometimes we can give someone a template in person and have them draft their answer. Then we also mail out templates. If we don't hear from someone or we're not able to connect, I sometimes will put an answer template in the mail so they at least have the format and are able to get something filed. Summons and complaint, all the paperwork that initiates a eviction lawsuit does now have to include a blank answer form, which does, I think it's sort of spotty whether we actually see if people have done that or not. But technically, tenants are supposed to be getting a blank answer form with their paperwork as well. And that, I think, concludes our training. So thank you very much for everyone who stuck it out 4 minutes after the time we said we'd be done. But we're glad that so many folks came out today. We appreciate it. If anyone does have any questions, again, you can certainly email us, call either one of us at any point. And I see some people are starting to drop their email into the chat. Thank you so much. We'll definitely get this training out to you as soon as possible. Anything else, Bradley?
Nope, I think that's it. If you want the materials, email in the chat. And thank you so much for coming. We really look forward to hearing from you.
Thank you so much, everybody. We hope you have a great Thanksgiving.